Hello everyone and welcome to Together We Can and We Will YouTube channel. Today I'll be talking about the overview and recent developments on the new proposed bills that are replacing IPC, CRPC and the Indian Evidence Act. So let's dive right into it. However, before we dive into the topics, let us understand what exactly does this video bring for you. We have the overview at first. We'll be talking about an overview of the new proposed bills. Secondly, we'll be focusing a little bit about the acts that are in power or being used in the courts of law at the moment, that is IPC, CRPC, and the Indian Evidence Act. Further, we'll be focusing on what all changes have been proposed in the present acts that have been proposed in the new bills. So, we'll be comparing them a bit and we'll be focusing on what all new developments have been taken place in this particular aspect. So, let's start. Union Home Minister Amit Shah on Friday, 11th August 2023, tabled three bills in the Lok Sabha: the Bharatiya Nyaya Sanhita Bill, the Bharatiya Nagrik Suraksha Sanhita Bill, and the Bharatiya Sakshi Bill, which would replace the colonial era Indian Penal Code, Code of Criminal Procedure, and the Code of Indian Evidence Act, respectively. Amit Shah said that the current laws have a British colonial stamp over them and were not meant to protect the common people of the India. He stated that these laws were made 160 years ago with an aim to create an atmosphere in favor of the British authority in London. The foundation of these procedures were to protect the British and not the common people of India. The three bills that have been proposed are Bharatiya Nyaya Sanhita Bill, which would be replacing Indian Penal Code of 1860, the Bharatiya Nagrik Suraksha Sanhita Bill, which would be replacing the Code of Criminal Procedure 1898, and the Bharatiya Sakshi Bill, which would be replacing the Indian Evidence Act 1872. Now, let us look at some brief information about the three acts that are in power and in use in the courts of law, that is the Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act. First off, we have the Indian Penal Code. The Indian Penal Code is the main criminal code of India. It extends to the whole of India. It has 23 chapters and 511 sections. The draft of Indian Penal Code was prepared by the First Law Commission chaired by Thomas Macaulay in 1835 and was submitted to the Governor General of India Council in 1837. But the draft was again revised. The draft was completed in 1850 and the code was presented to the Legislative Council in 1856. Following the Indian Rebellion of 1857, then underwent a very careful revision. It was passed into law on 6th October 1860. It came into force in the British India during the early British Raj period in 1862. However, it did not automatically apply in the princely states, which had their own courts and legal systems until 1940s. This code has since been amended several times and is now supplemented by other criminal provisions. Moving forward, we have the Code of Criminal Procedure. The Code of Criminal Procedure is the main legislation on procedure for administration of substantive criminal law in India. It was enacted in 1976 and came into force on 1st April 1974. It provided machinery for the investigation of crime, apprehension of suspected criminals, collection of evidence, determination of guilt or innocence of the accused person, and determination of punishment of the guilty. At present, the Act contains 484 sections, 2 schedules, and 56 forms. The sections are divided into 37 chapters. Next ahead, we have the Indian Evidence Act. The Indian Evidence Act, originally passed in India by the Imperial Legislative Council in 1872 during the British Raj, contains a set of rules and allied issues governing admissibility of evidence in the Indian courts of law. The law is mainly based upon the firm work by Sir James Stephen. The Indian Evidence Act 1872 has 11 chapters, 167 sections, and came into force on 1st September 1872. It applies to all judicial proceedings in or before the court, including the court martial. Now that we have already studied about the three acts that are in power and in use in the courts of law, let us look at the new provisions that have been proposed in the new bills. The various changes that have been proposed in Bharatiya Nyaya Samhita are as follows. The bill defines terrorism and offences such as separatism, armed rebellion against the government, challenging the sovereignty of the country, which were earlier mentioned in various different provisions of law. It repeals the offence of sedition, which was widely criticized as a colonial relic that curbed free speech and dissent. It prescribes capital punishment as a maximum sentence for mob lynching, which has been a menace in the recent years. It proposes 10-year imprisonment for sexual intercourse with women on false promises of marriage, which is a common form of deception and exploitation. The bill introduces community service as a form of punishment for specific crimes, which can help in reforming offenders and reducing overcrowding in the prisons. The bill also fixes a maximum limit of 180 days to file a charge sheet, which can speed up the trial process and prevent indefinite delays. Next ahead, let us have a look at the changes proposed in Bharatiya Nagrik Suraksha Sanhita Bill 2023. It promotes the use of technology for trials, appeals, and recording depositions, allowing video conferencing for proceedings. The bill makes video recording of statements of survivors of sexual violence compulsory, which can help in preserving evidence and preventing coercion or manipulation. The bill mandates that the police must inform about the status of a complaint in 90 days, which can enhance accountability and transparency. Section 41A of CRPC will be renumbered as Section 35. This change includes an added safeguard stipulating that no arrest can be made without prior approval from the officer at least at the rank of Deputy Superintendent of Police, especially for offences punishable by less than 3 years or for individuals above 60 years of age. The bill requires that police consult the victim before withdrawing a case punishable by 7 years or more, which can ensure that justice is not compromised or denied. It allows absconding criminals to be tried in absentia by court and sentenced to, which can deter fugitives from escaping justice. It empowers magistrates to take cognizance of offences based on the electronic records such as emails, SMSs, WhatsApp messages, etc., which can facilitate evidence collection and verification. Mercy petitions in death sentences to be filed within 30 days to the governor and within 60 days to the president. No appeal shall lie against the president's decision in any court. Let us have a look at the main features of Bharatiya Sakshi Bill, or what all changes have been prescribed here. The bill defines electronic evidence as any information generated or transmitted by any device or system that is capable of being stored or retrieved by any means. It lays down specific criteria for admissibility of electronic evidences such as authenticity, integrity, reliability, etc., which can prevent misuse or tampering of digital data. It provides for special provisions for admissibility of DNA evidence such as consent, chain of custody, etc., which can enhance accuracy and reliability of biological evidence. It provides expert opinion as a form of evidence such as medical opinion, handwriting analysis, etc., which can assist in establishing facts or circumstances relevant to the fact. It introduces the presumption of innocence as a fundamental principle of criminal justice system, which means that every person accused of an offense is presumed to be innocent until proven guilty beyond reasonable doubt. So these were certain changes that have been prescribed in the new bills. As you have heard and as you have understood, these changes bring forward many new issues that India has been facing recently. And they prescribe many new forms of theories, such as the reformative theory, when it stated that reformation would be used as a new form of punishment. However, now let's have a look at the recent developments that took place. Madras Bar Association on Hindi names for criminal law bills has termed it as unconstitutional or against the constitution. The Madras Bar Association has deemed it unconstitutional for the centre to replace the Evidence Act, Criminal Procedure Code, and the Indian Penal Code in Hindi. The association criticized the centre's decision to replace the names with Bharatiya Nyaya Sanhita Bill, Bharatiya Nagrik Suraksha Bill, and Bharatiya Sakshi Bill. In this regard, the group has also adopted a resolution. Madras Bar Association called the move an attempt to impose Hindi and advocated for the English names to be retained. In a joint statement, the president of the Madras Bar Association and secretary said that the extraordinary general body meeting of the Madras Bar Association held on August 23 resolved unanimously to express the objection and anguish over the naming of the bills in Hindi. They stated that this move is against the provisions of the Indian Constitution, and it is further resolved that the suggestions, views of this bill will be sent shortly to the Minister of Law, Government of India, with a request to reconsider and restore the original names of the above mentioned act. That's all for today's video. I hope you liked the video, and if you did, and if you would like us to make further videos on the 3 proposed bills that specifically talk about each of them, please comment down below. If you have any doubts, you can leave them in the chat box or in the comment box. We'll get back to you. If you have any specific topics in mind, please let us know in the comment section and we'll be moving forward with it. Thank you for watching the video. I hope you liked it and you understood the content well. Please like, share and subscribe the video and visit the website as well for further information. Thank you.